Good to see you, Ron.
Jonathan, how are you?
We're back at it again.
It's my pleasure.
Let me share the screen here. I've got a few slides that I put together for this presentation. So my name is Jonathan Goins. I'm a partner at Lewis Brisbois. I'm happy and proud to have a co-presenter here, and Ron Katz. He speaks and writes on pretty much all things sports and ethics. I'm going to go through a few slides just to lay the foundation of what we're talking about again today, and then I'll turn it over to my colleague who typically gets emotional on this topic. So we'll see if he does the same this time around. So what are we talking about here? We're talking about persona rights, NIL, right of publicity, and from a trademark perspective, false endorsement. And those names are somewhat interchangeable. Some people say name, image, and likeness. Some people say NIL. Some people say right of publicity. Some people say persona rights. The persona concept comes to us from McCarthy, who's one of the kind of guru trademark experts. So from his perspective, a persona right is essentially a distinctive characterization and its name that can be protected from a trademark perspective. Right of publicity, those elements are pretty straightforward. It's about someone's name, image, or likeness that has been used without their consent in a commercial manner. And so those elements typically are just the first three that I listed. You got to have the identity element. There has to be something in particular that is being used that is recognizable with your identity. Most practitioners will and most people in general will simply say NIL or name, image, and likeness. But obviously there are other aspects to that can be recognized as a part of the identity element as well, such as one's voice. The second element by far, this is the element that gets litigated a lot, which is, was that use misappropriated in a commercial manner? Was it misappropriated for purposes of advertising and trade? Third element is always the easiest to satisfy. The person who used your name, image, and likeness didn't have consent. Fourth element, this just depends on what state that you are pursuing your claim in. The state of California, for example, they actually do require some sort of causation or injury element. Most states do not require that, including New York and where I come to you from in the state of Georgia, but California does. So there is no federalized right of publicity law yet. There is no federalized name, image, and likeness that has passed by Congress yet. There have been legislative proposals. I do think before I stop practicing, God willing, I'm 18 years in now, 2002, proud graduate of Howard. I would like to think within the next 5 to 10 years, we will have a federalized right of publicity law, just like we have a federalized trade secret law. It's one of the last laws that President Obama passed before his tenure was up. All right. Why do we talk about trademarks? And just so you know, these are trademark registrations that are behind me. These are not my personal Hall of Me diplomas. These are not my personal accolades. These plaques that you see behind me are actually a lot of my clients' federal trademark registrations. Trademark can be a name. Without question, there are plenty of celebrities, talent, artists, sports, athletes that have their names federally registered as a trademark. All right. The advantage to that clearly is that one can pursue a cause of action, not just for right of publicity, but also for trademark infringement or for false endorsement. False endorsement is by far the complementary trademark cause of action that one can pursue in addition to a right of publicity. And it's typically, or excuse me, most specifically and notably, Section 43A of the Trademark Act, which again, it explicitly identifies that someone's name or their logo can be a protectable trademark. And then of course you have to prove likelihood of confusion as well. Right of publicity, if you noticed, you don't have to prove confusion. Right of publicity is more about your individual persona in which it was exploited without your permission. Trademark is more about someone is confused into thinking that your name was tied to that endorsement of a product or service. All right. What do we see that's happening with celebrities and sports figures? They are developing and protecting their persona branding. Michael Jordan is by far, I think, one of the leaders in this regard. He has not hesitated to sue in federal court if you've used his name, image, or likeness or his trademark without his consent. And he has a number of federally registered trademarks that are covering his name. Tiger Woods, I think, is also another notorious litigant. He has not hesitated in the past to sue for right of publicity or trademark violations. So a lot of sports athletes are catching up, and there's going to continue to be this trend of adopting their name as a trademark, adopting a logo as a part of their likeness and right of publicity protection. This is now also trickling down to the college level, which is what the bulk of what we'll talk about here today. And, you know, I put this slide up here just so you can see, you know, a number of athletes have adopted logos, from Michael Jordan to Ken Griffey Jr. to Tiger Woods to Kobe, the late Kobe Bryant, to JJ Watt, to Kevin Durant, LeBron James, Kyrie Irving, Tom Brady, the list goes on. NIL litigation. This was all about this particular rule right here. You authorize the NCAA to use your name or picture to generally promote NCAA championships or other NCAA events, activities, or programs. It's essentially a lifetime waiver of rights to the commercial use of a student athlete's name, image, or likeness. At least that was the rule up until last year, June of 2021. The Supreme Court ruled in favor of student athletes. Essentially, they unanimously ruled that NCAA rules prohibiting student athletes from leveraging their NIL for financial compensation violated federal antitrust laws. So a combination to me of that ruling, as well as a groundswell of state by state NIL laws that were becoming, you know, getting adopted. Obviously, it started first in California, where Ron Katz is residing. So no question, California led the effort in this groundswell of NIL legislation. And to date, as far as I know, from what I checked, there's been a total of 28 states that have passed NIL laws. Most of them went into effect as of July 1st, 2021. So no coincidence. You have the Supreme Court's ruling in June of last year, and then you have many of the states taking effect with their NIL legislation just in the following month. So July 1st, 2021 was a big deal because, again, that's when a majority of states, of the 28 states, that's when their NIL laws took effect. So the NCAA obviously knew this, and they had to act fast to avoid a chaotic, imbalanced level of competition. So in response to the Supreme Court's decision and NIL state legislation, they have issued this interim policy in which student athletes can be compensated for endorsements, including other forms or certain forms of payment, so long as it is not obviously tied directly to their athletic performance on the field or in the courtroom. So now basically it's the wild, wild west. And I use this phrase that from, the Jerry Maguire movie, it's all about show me the money now. Student athletes can get paid, and they are definitely making efforts to expand on their proprietary rights and developing their branding at a much earlier stage now. So in showing me the money, if you just do a Google search or a Bing search, you'll see there's a number of multi-million-dollar endorsement deals that have been in the press, and so we're going to continue to see this trend. But a majority of the student athletes, though, they're not getting the multi-million-dollar deals. Instead, they're teaming up with local businesses, restaurants, participating in one-off marketing campaigns, and they're receiving smaller cash payments rather than the big paydays. I just want to single two universities out real quick, and then I'll turn the floor to Ron. University of Arkansas just released a report that they have been collecting data since July 1st of 2021. They have reported that 140 of its student athletes have participated already in some form of NIL activity, working with over 170 companies on at least 300 agreements, earning an average of just a little more than $4,000. So like I was saying, majority of the NIL deals, they're not multi-million-dollar deals or even six-figure deals for that matter. They're small. So that's something to be seen going forward. Ohio State, another example that I wanted to give here. So they have most colleges and universities now have their own NIL policy, and they're kind of adopting kind of the guidelines from the NCAA. So their policy, if you decide to play for Ohio State as a student athlete, you're allowed to get compensation for autograph signing, personal appearances, social media endorsements, camps, clinics, private lessons, and so forth. But there's one catch. There's one catch. This is true not just for Ohio State. There's other colleges and universities that are doing the same thing. You can have whatever deal you want, but it cannot conflict with an Ohio State agreement. It cannot be in conflict with a contract that is already in existence with the school. So Ohio State, it's a Nike school. So you are, as a student athlete, are not allowed to negotiate and obtain an endorsement for any product that competes with Nike. The same is true with respect to the Coca-Cola Company. Coca-Cola Company is exclusive beverage sponsor with Ohio State. So you as a student athlete, you cannot endorse Pepsi. You can't do a Pepsi deal. You cannot do an endorsement deal with any competitor of the Coca-Cola Company. You can't do any endorsement deal that involves a competitor of Nike. I went to the University of Louisville for undergrad. So University of Louisville is a It's an Adidas school. Just 45 minutes east of Louisville is Lexington, Kentucky, where the University of Kentucky is. University of Kentucky, like Ohio State, it's a Nike school. So it'll be very, very important that student athletes are paying attention to the fine print, and we'll continue to see whether or not those kind of quote unquote conflicts will be impeding student athletes' right and ability to make some money. All right, so with that, Ron, if you want to chime in, the floor is yours, my friend.
Okay, great. Well, thank you, Jonathan. This is the third year we've done this, as you mentioned, and I look forward to it every year. I want to thank Professor Matima for inviting me, and it seems now that the world is catching up with his vision of intellectual property as a very important aspect of social justice. So I congratulate him for that. First thing I want to do is to acknowledge error. When Jonathan and I first did this 3 years ago, I predicted that the NCAA would be irrelevant in 5 years, and I was wrong, because it's now 3 years later, and I think the NCAA is already irrelevant. They really, if you look at what they're doing these days, they really only do one meaningful thing, and that is put on a basketball tournament, the big dance, and that's it. They've decentralized everything else. They've amended their constitution. On NIL, they've just given up, and they are not, I would say, not only an irrelevant organization, but as I'll make the point later, that it's sort of good riddance that they're not there, because they really haven't been doing very much to help the people that they're supposed to be helping, which are what they call student athletes. I just call them students. They shouldn't be different from other students. They have been different from other students in the sense that if you are a famous violin player, or if you are a famous chemist or whatever, you can make as much money as you like if you're a student at Howard University or any other university. But if you're a famous athlete, you can't, or you couldn't. Now you can. So I think Jonathan did an excellent job of talking about the right of publicity, but I think that you can't really understate how powerful it has become, because what brought the NCAA down? What brought the NCAA down is intellectual property law. I mean, that's why we're all here. It's an intellectual property conference. And why is intellectual property law so powerful? I mean, when you think about it, you know, everybody likes to think that we have free speech in this country, or at least we used to think we had free speech. But in fact, we don't have free speech. Free speech is prohibited in many aspects, and many of those aspects come straight out of intellectual property law. If you think we have freedom of speech, I would challenge you to manufacture a sweatshirt that says Coca-Cola on the front. You'll see, even though that's speech, you'll see you don't have a right to do it. Or write a song that takes a lot of Michael Jackson's lyrics. I guarantee you, you're not going to be able to do that, even though it is speech. So intellectual property law is very important, very powerful. But I would say of all the intellectual property laws, right of publicity is probably the least well understood, and was for many years the least powerful. It doesn't come from the Constitution. It doesn't come from a statute. Most people don't know where it comes from. Well, it's interesting. It comes from a law review article. They say it's the article that launched 1,000 lawsuits. I think Jonathan may have brought 500 of those lawsuits as far as I was. Now it's not 1,000, it's probably more like 1 million. But the article was written by Louis Brandeis, was in the Harvard Law Review of 1890 by Brandeis and Warren. Brandeis, of course, later became a Supreme Court justice. Warren was a very distinguished lawyer in Boston. And the title of the article is one of the reasons, there are two reasons really why right of publicity didn't become very important for a number of years. And I think one of them was the title of the article, because the article was entitled The Right of Privacy. And that really was the motivation for the article. Warren was in a very distinguished family, and he gave a party, I think, where his daughter was there, his young daughter was there, and a picture was taken of her and it was run in the newspaper, and he was offended by that, and he got Brandeis to write this article with him. So that was one reason, because people don't normally equate right of privacy with publicity, although clearly if somebody uses your image to sell Coca-Cola, they're invading your right of privacy. I think the second reason is that back in 1890, there really wasn't the same kind of publicity for athletes that we have today, athletes or other celebrities that we have today. I mean, today, you can be a 13-year-old sensation on TikTok. You know, you can have millions of followers. Your persona is extremely valuable. We have mass media. Really, in 1890, they did not have mass media, and the value of images was much less than it is today. You know, obviously, if you were a famous opera star or something like that, you would have some value. But just for a, you know, run-of-the-mill college athlete, you know, your image would not have much value. But once you become part of a video game, for example, then that changes. So right of publicity really had a hard time for the first, I would say, 60, 70, 80 years of its existence. A typical case happened in 1941. It involved Davey O'Brien. Davey O'Brien was the best college football player that year. He was an All-American, won the Grantland Rice Award, etc. And his image was publicized by his school, which was Texas Christian University. It was all over the place. Of course, that was with his consent. And then he appeared on a calendar that was published by Pabst Beer. I don't know if I don't even know if they still have Pabst Beer. They had it when I was in high school because it was cheap. You know, people used to like to drink it, but or they could afford to drink it. Let's put it that way. So his picture, I mean, there were a picture of a number of All-Americans on this calendar, but his picture was the most prominent since he was the best player, and it showed him in his position of throwing a pass, and he was right across from a big picture of a big bottle of Pabst Beer. And he hadn't given them permission to do this. So he sued, and his suit got a very cold response. He actually lost his suit, got a very cold response from the district court judge and then from the Fifth Circuit. And basically, they said two things. One is, this is helping you. This is helping you because it's publicizing your image. You've tried to publicize your image. Now Pabst is doing you a favor. So that was one reason. They sort of didn't get the idea that Pabst was exploiting his image and making money off of his image. And then the second aspect of the case was that Davey O'Brien was a teetotaler. He did not drink. And furthermore, he was in an organization that was against alcohol. So for him, it was horrible that his picture was portrayed across from a bottle of beer. I mean, it really damaged his reputation. And here's what the court said about that, again, showing that they just didn't have a clue. This is the Fifth Circuit. There was no representation or suggestion of any kind that O'Brien or any of the other football celebrities whose pictures it showed were beer drinkers or were recommending its drinking to others. You know, keep in mind, his picture's right across from a bottle of beer. The business of making and selling beer is a legitimate and eminently respectable business, and people of all walks and views in life without injury to or reflection upon themselves drink it. And that association of O'Brien's picture with a glass of beer could not possibly disgrace or reflect upon or cause him damage. So things started progressing after that. That I would call sort of the Stone Ages, but it was 50 years after the Law Review article had been written. But things started progressing, and people like Michael Jordan, famous people, could win lawsuits. There was when Michael was inducted into the Hall of Fame, there was a campaign by a supermarket and called the Jewel Markets in Chicago, and they said basically we're Hall of Famers, and we like to keep company with Hall of Famers. They didn't mention Michael's name. They just had a picture of his shoes with the number 23, which everybody in the world knew was his number. And as Jonathan said before, you don't really have to have a picture and the name and address of a person to steal their persona. You just have to have something that's recognizable. And the number 23 is very recognizable in the field of basketball. And what Jewel Store said, well, we didn't even mention his name. It was just a public service announcement about, high quality, et cetera. Well, at the end of the day, they paid him $10 million for that. So that was good, but it was not something that really helped, let's say a run-of-the-mill football player who's used in a video game or something like that. And that changed. That changed in 2009. Actually, I had something to do with that because I got the idea of combining the right of publicity or the use of images with class action litigation. And that was something that really had to be paid attention to by video game makers, for example, like Electronic Arts, because they were using thousands of players' images, college players and professional players. They paid the active players, but they did not pay the retired players. And when we did that, that made a huge difference. That was really the big battle. And as I mentioned at the outset, another reason that right of publicity has not progressed, had not progressed very far, is that people said, well, you're taking away my First Amendment right. All I'm doing is saying Michael Jordan's name or using his tenant. That's my First Amendment right. And that had to be sorted out. And I think the main principle for sorting out the balance between the First Amendment and right of publicity was something called transformative use. And that also came out of California, the Supreme Court of California. And basically they said in a case involving the Three Stooges, if the artist does something to transform the image of the person, then they're not going to be liable for infringing the right of publicity. But there has to be some sort of transformation. And the video game maker, Electronic Arts, said, well, yeah, we're transforming. We've got this bands and we've got the play-by-play, and I mean, it's very transformative. And then what the court essentially said, and again, it's the Ninth Circuit in California and the Third Circuit in Philadelphia, hasn't gone to the Supreme Court, and I don't think it will. Basically, they said, you're not transforming anything. You're showing this football player as he is, doing exactly what he does, which is playing football. There's no transformative nature of this whatsoever. Well, that changed the world. That really did change the world. And then, as Jonathan said, the next change just came from the inequities of it all. I mean, when you looked at it, college sports really used to be amateur. There used to be 3 games a week on television. That was the limit. Until the 1950s, players couldn't even get scholarships. Later, they could get scholarships. But, it was a very small compared to what it is now. Now, if you turn on a professional football game or if you turn on a college football game between big-time college football teams, you can't really tell the difference. There's really no, the players are big and strong and the advertisement, everything is pretty much the same. So this created inequities because the business model of college football and college basketball, which are the only money makers, they had a great business model. Don't pay the employees. I mean, think about it. If any of you are in business or you're starting a business, how profitable that business could be if you don't pay the employees. I mean, it's a goldmine. It's great. And so what did they pay? What did they spend the money on? Well, they spent the money on coaches. The best coaches now make $10 million a year. They spent the money on facilities. And you don't have to be a great head coach to make $1 million. You could be the weight coach at Alabama and you could make $1 million. So a lot of money flowing everywhere except to the students. And of course, if you're looking at the sports of basketball and football, the majority of the students are African Americans. The majority of the players are African Americans. And you just create a situation where that is so unfair on its face that legislators around the country said, we just have to do something about this. And I'm proud to say that my state of California led the way. And of course, there was a tremendous hue and cry when they did it. The first thing the NCAA said, well, fine, now we're going to disqualify all the California schools from competing in our tournaments. And that, I think, was a pretty credible threat until the second state enacted this, and then the third state. And as Jonathan said, we've got 28, 29 states doing it. And I'm sure all 40 states would have done it. And why did they do it? Why did they do it? They did it because of competition. Because somebody sitting in Alabama, maybe Nick Saban sitting in Alabama, or John Calipari sitting in Kentucky saying, you know, gee, I'm getting the best football players right now. I'm getting the best basketball players right now. Not only am I getting them, but I'm not paying them anything. It's fantastic. Except, you know, these guys are not dumb. If they know that they can go to California and play for USC or play for Stanford or play for UCLA and make money, they're not going to come to Alabama or Kentucky. Why would you? Doesn't make any sense. And so what they did was they exerted their influence and they got their legislators to pass the same kind of law so that they could compete with California. So that really is what turned the tables and created the situation that we have today. And the NCAA tried to stop that. They tried to say, well, we'll make rules about competition. We'll make rules about NIL. And so we don't need to worry about those silly state laws. We'll just make our own wonderful rules. And they did. They made their own wonderful rules. But of course, the rules were terrible for the students. What they did was they made a rule. Instead of just doing what people have been doing for hundreds of years in terms of selling their images, what do? They go into, if you want to sell your image today, if Jonathan wants to sell his image, he could just go out in the free market and whatever somebody's willing to pay him, he could get. And he doesn't have to report to anybody or anything else. This is a free country. He's a free man. So, but that wasn't right for the NCAA. The NCAA doesn't really believe in freedom. They believe, I don't know what they believe. It doesn't matter anymore because they're not around, really. But so their rule said, first of all, you can't have any confidentiality. We have to know what you're doing. Well, anybody who's made a commercial deal, whether it's about NIL or anything else, knows you have to have confidentiality. You can't reveal your business to your competitors. I mean, that's just silly. And why did they have to know? Because they had to know, well, one thing, what Jonathan said before, we have to know if you're competing with us. We don't want you to compete with us. Well, doesn't that sound a little bit like an antitrust violation? Anti-competition? Michael Jordan didn't use the same brand that the Olympics did. You may recall when Michael Jordan played in the Olympics, he covered up the one of the logos because it wasn't his brand. Why shouldn't students be able to work for whoever they want to work for?
It was Reebok, yeah.
Pardon?
It was Reebok.
Reebok, yeah. They said you cannot have, the second part of the rule was you cannot use your image to promote products that conflict with NCAA legislation. Like, well, what would those products be? Alcohol, perhaps? Pot, perhaps? Well, guess what? It's legal. Pot is legal in most places. Alcohol is legal in most places. So why does the NCAA have the right to tell a student that he cannot lend his image to a legal activity? Well, you're all lawyers. Maybe you can tell me. I don't know. I don't know. I can't figure that out. And then the final killer was that you cannot lend your image to anything that violates your school's values. Well, what does that mean? I mean, who knows? I don't. Well, first, I went to Harvard. I don't know what my school's values were. Making money, I guess, being famous. I don't know what their values are. But I can tell you this, that if that is a rule, then they can stop anybody at any time, because all they have to say is, oh, this conflicts with our values. Sorry, you can't do it. So that was a non-starter. And then finally, the NCAA just gave up. That's why I say they're now irrelevant. And basically the rule today is totally decentralized. You can do what your college says you can do, what your conference says you can do. And so far, there really are no rules. And so basically what's happening? What happens in a free market? People make money. People promote themselves. People do all sorts of things. And the first person to do it, of course, was Nick Saban, the coach of Alabama. You know, his team has been dominant. And so last summer, when all this was new, as Jonathan said, the Supreme Court decision was in June. And in July, there were some changes. The state laws came into effect. And here we have, we're looking at a newspaper article from July 20th. Nick Saban is making a speech to the Texas High School Coaches Association. Now, why would Nick Saban want to make a speech at the Texas High School Association? Well, it might have something to do with the fact that Texas has a fantastic high school football program, produces among the greatest football players in the country. And of course, he's going to go and talk to those coaches because he wants those players ultimately to come to Alabama. So what did he tell the Texas High School Coaches Association? He said, well, look, I've got a quarterback. His name is Bryce Young. He was second string. He hasn't even played yet. He has not played it down yet. And guess what? He already has $1 million of deals. $1 million of deals for his name, image, and likeness. And why do you think Nick Saban is telling the Texas high school coaches that? Because he wants the coaches to tell their students, yeah, you want to make some money, you might want to go to Alabama. They're the big brand, you can make a lot of money. And finally, what Nick Saban said on that day was, you have to understand, I'm quoting him, you have to understand that everybody has a different amount of opportunity relative to what's going to happen here, Saban said. Everything in college football, everything in high school football has always been equal for everyone. It's not going to be that way anymore. Well, I disagree with him. There is no equality in college football. Do you think Howard's going to play in the finals of the NCAA this year? Do you think Harvard's going to play in the finals of the NCAA? No, we know it's always the same teams. It's always Alabama, Ohio State. There is no equality now. And guess what's going to happen under this system? The rich will get richer and the poor will get poorer, because that's what happens in a capitalistic system. It's really not very surprising. But then Nick Saban sort of changed his tune because they came out with the recruitment class. One of the big things that happens in college football is that the classes that the coaches recruit are rated. This is the best recruiting class. This is the worst recruiting class, and everything in between. So this year, Texas A&M, whose coach's name is Jimbo Fisher. One of the things I like about having litigated in sports is that the names are always better. So Jimbo Fisher, he got the number one recruiting class this year. And then, because we live in a social media age, there was some sort of website called Bro Bible. I'm not familiar with it. And there was a guy on Bro Bible, and his name was Sliced Bread. It's not my generation, but whatever. Then Sliced Bread posted something which said that Jimbo got his best class because they had a $30 million fund, including NIL stuff. And this, Jimbo was very upset about this. He said this $30 million deal is a joke. the thing that there's some fund out there and it was written on Bro Bible by some guy named Sliced Bread, and all of a sudden the country believes it, is a joke. Well, we've already seen Nick Saban was advertising what they could get, but Nick wasn't too happy about this, and the other coaches weren't too happy, and they started they're saying, basically, this is out of control now. Because you're not supposed to use this. We have this NIL is okay, but you can't use it for recruitment and you can't use it to pay your players. Well, money is fungible. If, let's say I was the best college player in the country and I'm going to go to Stanford, my local school, and some booster from Stanford comes to me and says, well, Ron, we'll pay you $1 million in salary to come to Stanford and be our quarterback. I'd say, great, okay, I'll do it. And then Booster goes back and then he comes back to me later and he says, well, we found out we can't pay you a salary of $1 million to come to Stanford. So how about this? We'll pay you $1 million for your name, image, and likeness. I said, okay, fine. I'll still come to Stanford. Because from my point of view, $1 million is $1 million. I don't really care what you call it. So basically, there's no standards anymore. You can say that you can't use it for recruitment. You can say that you can't pay players, but it's just not true. It's just not true. So that's one aspect of what's happening with NIL. Another aspect is that the females are starting to profit from this as well. I'm reading from an article. My local newspaper is the San Francisco Chronicle. And there was an article on March 2nd, just 2 days ago in the Chronicle. And the headline on the sports page, it says, "Set me up for life. Female athletes stashing NIL cash." And it quotes a woman named Masai Russell. She's a track athlete. And she's doing a lot of social media, TikTok, things of that sort. It says Russell's 20 or so NIL deals include Walgreens, Hulu, and WWE. Most of her NIL activities have been on social media, which has left her wanting to explore who I am outside of just pictures. Quote another woman named Deja Kelly, who's a gymnast. She says, "It's a generational opportunity. It'll set me up for life. If I were to stop playing basketball in 5 years, I would be fine because all the things I'm setting up now and focusing on now." And it talks about LSU gymnast Libby Dunn, one of the most recognizable college athletes on social media. She has 1.5 million followers on Instagram and 4.8 million followers on TikTok. She said in a written response to questions that she has about 10 deals, most of them recurring, and then she's a top earning athlete in the NIL space. And even Howard University is getting in on the act. Have an article here. It says, moving company inks deal with Howard University hoops. Moving company College Hunks Hauling Junk made a big splash by signing the Howard University men's basketball team to an endorsement deal. It's believed to be the first deal of its kind with an entire team from an HBCU. And this is very significant because basically you're putting the team on payroll. You're saying if you come to Howard and play basketball, you're on our payroll. You're going to get paid. It's a brilliant idea. And they can't stop it because they just say, oh yeah, we're just paying them for their image. So what is the NCAA doing about all this? Well, what the NCAA is doing is what they usually do. They're forming a committee and they're trying to explore what happened, investigate what happened. Well, I've got a suggestion for them. Just read USA Today. You'll find out what happened. You don't have to have a committee. You don't have to do research. You just have to read your morning newspaper and you'll find out what's happening. And what's the assignment of this committee? The assignment is that they have to look into the following questions. This is from the D1 Council. And their report is due in April, in case you're waiting at the edge of your seat for it. Here's what it will study. School choice. What role is NIL playing in recruiting, whether it's high school athletes or college transfers? Well, I can tell them it's playing a huge role. If one college offers you $1 million and another one offers you $10, You're going to go to the one that offers you $1 million. It's very simple. And this not only applies to high school students, but it also applies to transfers. The Oklahoma quarterback was going to transfer, and he was offered $1 million to go to Eastern Michigan from Oklahoma. So that's the answer to that question. And the second thing they're looking into is deal making. How active can schools be in arranging deals for athletes? Where do they draw the line? The answer is there is no line. What is the effect on athletes' mental health and their academics? Well, I don't know about their academics, but I'm sure their mental health is a lot better if they're becoming rich. Enforcement, just how much trouble can schools get into for breaking the temporary NIL rules? And the answer is nothing, no problem, no enforcement, no problem at all. It's the free market. So we've lost the NCAA. They're just putting on a basketball tournament now. That's all they really do. And is it good or bad that they're gone? Well, the latest report is that they paid their president $2.9 million in 2019 and 2020, which was a raise. He got a raise, even though the revenue of the NCAA went down $500 million that year. So I don't know why you would get a raise under those circumstances. There's 3 other officials who are earning over $1 million a year. The last reported time, they spent $68 million in legal fees. Now, I'm sure Jonathan's happy to hear that, but still, would you, and really Howard's paying part of that. Howard's in the NCAA. So you might want to think about that. And $500,000 for lobbyists, which I'd say is a bargain compared to the $68 million. Plus, how are they doing for these students that they say that they're looking out for? How are the graduation rates doing? Well, the University of South Carolina compiles a figure which it calls the adjusted graduation gap. It compiles it for D1 basketball. For men's D1 basketball, the adjusted graduation gap is minus 24.9 for basketball players. That means that basketball players at D1 schools graduate at 24.9% less than students who are not basketball players. And for African Americans, the AGG is 44%. So I would say that intellectual property has done away with the NCAA, and I would say more power to intellectual property. Thank you.
Looks like we have one question in the chat function. Have you seen any impact on fantasy or video game play since the NIL legislation? I mean, well, so during the Ed O'Bannon lawsuit, and you know, to me, he was somewhat of a sacrificial lamb in the sense that he lost, but ultimately overall still won the. He may have lost the battle, but overall won the war, because it was Ed O'Bannon, I think, that really was instrumental in getting more attention, more of the media becoming attentive to student athletes and their ability to be able to capitalize on their name, image, and likeness. So, but in that lawsuit, in that litigation, EA Sports took that very position. They said that, well, this is a video game and this is transformative. This is transformative fair use, to what Ron was mentioning, and the court did not buy that. They rejected that fair use defense argument, which is ultimately why EA Sports settled shortly thereafter. So, and obviously there's you know, Epic Games and their usage of imitating those who have done popular and famous dances, from the Carlton dance to doing the floss. Most of those lawsuits were not successful. Even Carlton, I think, attempted to obtain a copyright for his dance, and the Copyright Office rejected that. So I've not seen much success for the creative artist or the talent whose name, image, and likeness has been used in video games. But I do think that could be changing. The metaverse, the virtual gaming will be interesting to see if you have name, image, and likeness and right of publicity on the one side, and you have fair use, transformative use with First Amendment defense on the other side. That tension is certainly still in existence, and it's going to continue to be for quite some time, I think. Ron, any comment from you about?
I think they're selling more video games than ever. I mean, again, the model, the business model of the video games was, we're not going to pay certain people. We're going to have a college football video game, but we're not going to pay them. Well, now they have to pay them. So they did take it off the market for a while, but I think now it's back. With respect to the EA Madden game, I think they're now paying the retired players. So the idea that you have to pay your employees is not a revolutionary idea.
Yeah. Well, since we have, I guess, a few minutes left, I'll share the screen here impromptu and show Ron the Michael Jordan ad that you were speaking of. So this is the ad that Ron mentioned. He was talking about this Sports Illustrated ad that ran shortly after Mr. Jordan was inducted into the 2009 Hall of Fame, Basketball Hall of Fame, NBA Hall of Fame. And so if you notice, his actual name is not used. They don't actually mention, well, they do mention his name, Michael Jordan's elevation. But that's not what his issue was. His issue was the use of the shoes, the number 23, and the linkage of his name specifically to Jewel Osco's own trademark logo, and also the phrase "just around the corner." If I were to blow this up, the phrase "just around the corner," that advertising tagline, is actually, as a part of the trademark logo itself, it's underneath the Jewel Osco name. Good things are just around the corner. So that linkage to the Jewel Osco trademark, I wrote an article on this with Professor Stephen McKelvey a while ago, and I did interview one of the lawyers for the Jordan team, and they said what really got the lawsuit going and what allowed them to be successful ultimately was the use of the Jewel Osco logo, so closely intertwined with Michael Jordan name and his image itself, that kind of tipped the scale. So, and interestingly, actually, in the district court level in that case, the district court actually found against Michael Jordan. They actually had stated that simply making a congratulatory message was protected by the First Amendment defense, because it was just a way of congratulating Mr. Jordan on his Hall of Fame induction in a non-commercial manner. The Seventh Circuit, though, reversed that decision, ultimately finding that there was image advertising at play, and some could be led to think that he could have endorsed that ad. So I think I was able to add a filibuster by giving that ad real quick, and that got us to our limit here. But as always, it's a pleasure to be a part of you. I look forward to seeing all of you in person live next year.
Yeah.
I can't wait.
Amen.
Thank you so much, Jonathan and Ron, for your insights. I'm going to share my screen for the last CLE attendance verification code for the session. And the CLE verification code number 5 is social justice. I just want to give everybody a reminder that the last session of the day is the ethics session that starts at 4:35. And I hope everyone have a great day.
Thanks again. Good seeing you, Ron.